Now, the Constitutional Court has dismissed Public Protector Busisiwe Mkhwebane's efforts to appeal a ruling that found that she wasn't entitled to subpoena the former President Jacob Zuma's tax record. For an analysis on this, I'm joined now by Ms. Joon Chong, a tax expert. Ms. Chong, thank you so much for your time this afternoon. Perhaps let's go into the basics of who is actually able to access an individual's tax records, which organs of state, and how do they actually go about getting access to these tax records?
Thank you, Tammy. Firstly, the Tax Administration Act contains very strict confidentiality provisions to protect taxpayer information. There is a closed list of public entities in Chapter 6, which allows for certain public entities only to access such information. And if the public entities is not one that is listed in Section 69 and 70, then SARS is not at liberty to disclose that information. So we see, for example, the SAPS or the NPA in the course of performance or duties under a tax act or customs and excise as a witness in criminal proceedings, or taxpayer necessary to enable a person to provide such information as may be required by SARS from that person. And then we also see, for example, when SARS needs to disclose such information in order to the NPA, in order to commence with a criminal prosecution. Unless the specific requirements in the TAA provide for a public entity to access such information, then SARS is not at liberty to provide the information to the public.
So if you could talk to us about, I guess, the logic of the public protector not being granted this information. I mean, our understanding is either an individual will have to legally apply for them in court or ask the former president to furnish such tax records. The body and the office that the public protector holds, surely that should have been one that allows her to have access to such information. What are the specifics that have barred her from having this access in this particular instance?
Tommy, I think that the provision that she's relying on is Section 7.3 and 7.4 of the Public Protector Act. The Section 7.3 and 7.4 of the Public Protector Act does provide for the powers of the public protector to issue subpoenas to request information. However, Section 69(2) provides that there is secrecy of taxpayer information and against general disclosure under any other act, unless the statute itself expressly provides for the disclosure of such information. This is not unique to the Tax Administration Act itself. If we look at the PAIA, Section 35 of PAIA also prohibits disclosure, prohibits SARS from disclosing taxpayer information generally. So therefore, SARS is intending to protect taxpayer information. And unfortunately, 11.3 provides that there is just cause in not complying with the subpoena when there is just cause. And the SARS ground of not complying with the subpoena is thus that Section 69 overrides the public protector subpoena because there is no specific provision allowing for the commissioner to disclose such taxpayer information.
So there basically would need to be an amendment of the law in order for the public protector to be able to, I guess, go against Section 69 too.
Yes, most definitely. You would need to amend Section 69 itself if you want the public protector to have such information, taxpayer information, by way of a subpoena. You would go through that in your normal tax amendment process, which is an annual process to amend the tax amendment, the tax statutes. That's your Income Tax Act and so on, and also the Tax Administration Act. One of the grounds that the public protector raised was that the authority to subpoena request information is a constitutional right in terms of Section 182. However, the High Court judgment already has pronounced that the authority to subpoena is not from a constitutional right. It's an additional right which is derived by way of statute, which is the Public Protector Act itself. It's not a constitutional right. Therefore, because the Public Protector Act is now almost below that of the Tax Administration Act, and we rely on the legal principle called the specific provisions will trump the general provisions, and because the general provision in the subpoena provision of the Public Protector Act is not, thus must not override the specific provisions in the Tax Administration Act. If government, that would be National Treasury and as a matter of policy as well, Parliament, if they do feel that it is necessary in the public interest to allow the commissioner at certain specific instances, situations, that the commissioner should be allowed to disclose such information, then the Tax Administration Act itself, Section 69 specifically must be amended. And it must go through that whole public participation process so that stakeholders and taxpayers can themselves provide comments which will be taken into account and discussed. All issues of allowing this inroads into confidentiality of taxpayer information will be properly ventilated in that public participation process, and then we can amend the law. But before that, it is going to be extremely difficult to allow a sort of, to read in a public interest purpose into Section 69 to say that perhaps in an investigation of potential corruption, we should allow the commissioner to release the information pertaining to the taxpayer as requested in the subpoena. It's very difficult and very dangerous and contrary to the rule of law to allow such a reading in of that public interest purpose.
So Ms. Chong, what are the implications of this ruling?
Unfortunately, we don't have the judgment yet. However, I had a quick look at the YouTube video. I think that when the judgment was read out, and there were 5 points. Well, firstly, I think this is a triumph for the rule of law. We've got Section 69(1). It's deeply entrenched now, and as in many other constitutional court judgments. And the rule of law that we are focusing now is that confidentiality of taxpayer information remains pivotal and remains vitally important. And then the other important points, as read out by the court this morning, is the court found that the public protector had acted in fraudem legis in issuing the subpoena, had acted in bad faith when she, in discussions with SARS, implied that she did not have funds for the first senior counsel opinion. Third point, she acted in bad faith by not involving SARS when instructing the second senior counsel to get a second senior counsel opinion. She acted in bad faith. She's inclined to act outside the law. She acted with deep-rooted recalcitrance to disregard senior counsel and junior counsel's advice to approach the court herself to get a judgment allowing her to access the information, or alternatively to obtain the taxpayer's consent. And the fifth is that she is expected to act with a high degree of perfection. Unfortunately, she failed to do so. I've tried to paraphrase. Any errors is my errors. So there are 5 points from the judgment this morning, and it's an extremely important judgment because firstly, it shows that taxpayer information is still a very important right and must be protected at all costs. It is pivotal and centered to the whole social contract between SARS and taxpayers. It's a social contract which forms the basis of us taxpayers to disclose and file our tax returns completely and timeously, and to provide this information completely, comprehensively, timeously in the course of verifications and audits. Because without this social contract and without the proper functioning of the social contract and the trust between the taxpayer and SARS, there cannot be proper collection of revenue, which is badly needed in this country for meaningful economic growth to happen. Therefore, the importance of this judgment is that the right to privacy, which is linked to confidentiality of taxpayer information, is very well protected. That's the first. And then the second is that the direct access to law by a public protector who's now acted as the judge as the Crown Court has read out all these 5 points, has been dismissed. Leave to appeal is dismissed. It underscores the independence of the Constitutional Court and is very much a triumph of justice and rule of law.
Before I let you go, Ms. Chong, under what circumstances can these records actually be made available? Say, for example, there was a huge contravention of the law and it was indeed in the public interest, for these records to be made accessible to an organ of state. If it was the NPA, for example, would they have been able to access these records?
I think we need to draw a difference between information which is already in the public, that can be disclosed, and information which is very private, confidential taxpayer information. And the specific information requested in the subpoena, in the 2018 subpoena, which is the payroll reconciliations of Raw Security CC, which would have all the employee information. That is very much not in the public domain, and that can only be disclosed under very specific, strict provisions in the Section 69 and 70. And if those, if it's not by order of a High Court, if the information is not public, then it cannot be disclosed.
Well,
strictly cannot be disclosed.
Ms. Chong, thank you very much for a very comprehensive analysis of the intricacies of Section 69(2) and the tax laws there, which, as you can clearly see, are very stringent and really erring on the side of maintaining the confidentiality of taxpayers. They're a summary of what this particular judgment means for confidentiality regarding tax affairs of South Africa.